And again, instant or relative to the emergency medical response, Minneapolis police officers are required to request EMS as soon as practical, correct?
Correct.
And so there may be certain things that prevent an officer from calling in EMS, right?
Absolutely.
So I kind of got in late. Sorry about that. I'm not sure who this witness is or what she's testifying to, but since he's doing a cross, I wanted to try and get down on it.
So both of the medical policies are somewhat qualified or contingent upon what's going on at the scene at the time, right?
Yes.
Now, in terms of, I believe it was this, Exhibit 111, which is the CPR presentation that you've presented, turn to I'm going to turn to
Could have fixed her hair for
Bates
trial.
21856 down at the bottom there. There is a reference to agonal breathing.
Yes.
What is agonal breathing?
Agonal breathing is something you'll see in somebody who's unresponsive and they're in some sort of respiratory distress. We see this quite often with opiate overdoses, medical emergencies, drownings, what have you.
And can you describe what exactly agonal breathing is?
Well, by name, it's kind of a bad term for it because it's not effective breathing. It's more or less kind of an irregular gasp for air.
Okay.
It's really just kind of like your brain's last ditch effort to try to pull some air in.
And a person observing someone going through agonal breathing, it's common, or it would be possible that they would misinterpret that as actual breathing, effective breathing.
Yes, it can be easily confused with real breathing, so that's why we teach this is not effective breathing.
Right. So an officer is dealing with someone who's experiencing agonal breathing. It would potentially be possible for an officer to misinterpret agonal breathing for effective breathing.
Okay.
And in certain circumstances where there's a lot of noise or a lot of commotion, would it be more likely that that could happen?
Yes.
Now, you were shown this slide in terms of when do we stop CPR. And one of the reasons you stop performing CPR is because it's not safe, right?
Correct.
And by it being not safe, are you referring to the process of actually giving CPR or the environment that you would be doing it in?
It would be the environment around you.
Okay. And so it stands to reason that if the environment around you you would determine to be not safe, you may not start it right away.
That would be reasonable, yes.
Okay. Now, you also testified.
She's actually being a pretty fair witness to him. She's not appearing that she's given any bias. I didn't see her earlier testimony, but she's sitting there, she's leaning forward, she's answering his questions, and I don't detect any attitude or negative kind of resistance like a lot of the witnesses have given the defense.
That you teach on Narcan and the use of Narcan.
Correct.
And I am going to show you. You can see this training in front of you.
Yes.
Is this training that you provide to Minneapolis police officers?
Yes.
And this is the this is the program on like the broader course on how to administer Narcan, correct?
Correct.
And do you recognize this as a record that you keep in the ordinary course of your business?
Yes, sir.
This, Mr. Slisher, I had labeled as...
Every witness should be told, your job is to be truthful and honest, and you're educating the juror. Don't make up stuff. Don't be afraid to say, I don't know. And don't work for the prosecution or the defense. Just be truthful. If every witness was told that, they would probably testify better. But unfortunately, they're told, you don't want to hurt the prosecutor's case. Be careful what you say. Don't volunteer information to the defense that might hurt the prosecutor. And it's, again, the government stacking the deck. Can't go forward, so we're on real time. Why is it taking so long?
it's doing this. Here we go. And permission to publish 1041. This is from the Minneapolis Police Department in service from July of 2018.
Correct.
And if Mr. Chauvin had attended this program and or his in-service in July or through September of 2018, he would have received this training, correct?
Correct.
Now, in recent years, fentanyl has become more of a concern for officers to be aware of, correct?
Absolutely.
And ultimately, you train officers in the use of Narcan to contraindicate, or to contradict, I should say, the effects of Narcan, right? Oh,
The effect of opiates. Yes.
Including fentanyl.
Correct.
Right? Now, in your experience as a police officer and as a medical trainer, have you experienced individuals who take combinations of drugs?
Yes,
Have you heard the term speedball?
I have.
And would you agree that that is generally the combination of both a stimulant like methamphetamine and a depressant like fentanyl?
Yes.
And
Sidebar, Your Honor?
Sidebar. Huh. I'm not sure what the issue was with that question. Would you agree that it could be fentanyl a speedball? I mean, she was identifying a speedball as a stimulant and a depressant. Maybe he didn't like the fact that he was using both drugs that Floyd was on. Maybe he should have just used stimulant and depressant instead of stimulant and fentanyl or depressant. I really don't know what the objection is, but we'll see how he comes back. Sometimes we can tell what the objection was, or by how he asked the question again.
can you describe for the jury what a speedball is?
Oh, so he described it instead of asking a question and got her to agree. And they said he didn't ask a question. That was a BS thing, but okay. So now he's going to have her describe it.
It's essentially a combination of an upper and a downer.
And has that become
Upper is stimulant, downer is depressant, for those that don't know.
commonplace in your experience?
Yes.
Now, as fentanyl has become more prominent, do you see that in legal forms, such as patches or other pills that may be administered by a hospital?
Objection leading.
Wow, the defense is, the prosecution is kind of getting nervous with these questions, so he's objecting a lot. The more he objects, and especially when they're not sustained, makes him not look good, like he doesn't want the truth to come out. So he needs to be careful there.
Do you see that on the streets?
Yes, you'll see totally legitimate pharmaceutical purposes, and then also illicit,
Also, when the prosecution objects and it's his witness, because she is his witness, he called her, the prosecution is putting on their case, therefore that she is his witness. When your witness, when you object, a lot of times when they meet with you, they go, look, if I object, it's because I don't want you to say something or I don't want you to answer, so be quiet and wait. So that sends a signal, even if it's not sustained, it still puts the witness a little bit like, uh-oh, the DA really doesn't want me to answer this, or uh-oh, he doesn't want me to elaborate, or uh-oh, I shouldn't go too deep into this. So it's still subliminal kind of cues to my witness, I don't want you answering this.
drugs that were manufactured outside of lines.
Can you explain for the jury whether, in your experience, you've seen illicit fentanyl use on the rise?
Yes,
Becoming more
absolutely.
And I'm going to just show you, generally when you talk about someone, you show it to officers in this training, when someone is on the experiencing an opiate overdose, you may see this type of behavior. Is that correct?
You could, yes.
Someone may fall asleep, someone may be very tired, kind of out of it, right?
Correct.
Objection leading.
Yeah, let's get back to the right question.
Sorry. Would this be consistent with what you would see generally on a opiate overdose?
It could be.
Have you ever been at a scene where an opiate overdose, someone can be more responsive,
Yes.
even though they've taken an opiate.
Correct.
Now, in terms of fentanyl, can you explain this slide?
Certainly. So this is a diagram to show you just what could be considered a lethal dose of fentanyl. Just it's more of a visual indicator because we already know how dangerous heroin is, and you can see a trace amount of that could be deadly with fentanyl, and even more so with carfentanil.
And so even fentanyl, even in very small doses, can be fatal. Would that be accurate?
Objection, Your Honor. Sidebar.
I'll rephrase the question.
So by rephrasing, he's telling the judge, you don't have to rule on it. I'll just rephrase it. Fine. So it's kind of like sustained, but man, this guy's really coming out of his shell on objections on this witness, which if I was the defense, that means I'm keeping this witness up here as long as I can, because the more times I get you to object, the more it looks like you don't want this witness to say what's really happening.
Persist in the objection, Your Honor.
Uh-oh, sidebar. So this is a good witness for the cross to make some good points. Remember, the prosecution called his witness, who is his expert, and now he's going to get her to talk on how much drugs George Floyd had, how much can kill him, etc. That hurts the prosecution case. They don't want this to be about drugs. They want this to be about Chauvin's knee. So the more the defense or the prosecution doesn't want the drugs the focus. But they had to call him in. They had to call in somebody to testify because of the drug use. But again, they want to minimize the focus or questions or anything that can hurt their case relating to the drugs, because their whole stance is it wasn't the drugs. It wasn't George Floyd. It wasn't his resistance. It wasn't him fighting. It was all Chauvin's knee. And that hurts their case. So that's why you're seeing this, a lot of these objections and sidebars, and I don't want him questioning her on this, or you know what? He's going to get to call his own drug expert anyway, and he's going to be able to get all these questions in. So, I mean, he's been leading, they've both been kind of leading questions this whole time, and they've both kind of accepted it from the other. And they are letting people lead, because nobody wants to become this attorney that wants to stop everybody from talking, because then the jury kind of gets sour on you. So it'll be interesting here. I'll pause this and wait till they come back. Okay, it looks like they're coming back.
So these are the training materials that you present to Minneapolis police officers relevant to the use of Narcan. And
Sounds like he made an objection on foundation. He didn't lay a foundation to get in what they're used in training. So now he's going to come in and say, these are the things that you used. Now he has the foundation to ask about those. I think that's what they were probably objecting about.
And controlled substances that they may encounter while in their performance of their duties, correct?
Correct.
All right. Now, in terms of, and we can take this down, in terms of just again, general training, you had already said that you also discussed with officers the concepts of excited delirium, correct?
Correct.
And you provide them with training and materials about what that means, correct?
Yes.
All right.
Wow, he went away from the drugs. So whatever the sidebar was, the judge must have told him, you can't keep asking about drugs. Well, maybe that wasn't the objection foundation. I'm not sure what was going on.
And generally speaking, without reviewing to your training materials, can you describe what you train Minneapolis police officers about excited delirium?
Oh, maybe he objected to, see, you just kind of, it's a game on guessing on how he's questioned. So he goes, without referring to your material, maybe he objected that he was letting her use notes and he was showing her things to talk her through, and he wasn't asking her questions from her recollection, and that's why it was leading, because he was showing her the pictures of what he wanted. So that's why he said, without referring to your notes there, that leads me to believe that has something to do with the objection, or the sidebar, rather.
Certainly. And this is a class that is taught at the academy. It's a 1 hour block of 1 hour block of instruction to recognize the signs and symptoms of excited delirium and your best responses for handling that. So excited delirium, it's a combination of psychomotor agitation, psychosis, hypothermia, a wide variety of things you might see in a person or rather bizarre behavior. And recognizing that this is a medical condition, not necessarily a criminal matter.
Would that include discussion of controlled substances in the context of excited delirium?
Yes, because what we're usually teaching is that most of the people that are experiencing something like excited delirium, usually there's illicit drugs on board that might be a contributing factor.
And as far as what do you train Minneapolis police officers relevant to the physical attributes of a person experiencing excited delirium?
The person might be experiencing a hyperthermia, means elevated body temperature. That could be displayed with somebody taking off their clothes in a place it's not appropriate to take off your clothes, or in like the middle of winter or something like that. And just based on their activity, their heart rate might be extremely elevated, and they might be insensitive to pain.
How does it affect strength?
Because you don't really have that pain compliance.
It's not pain compliance. You don't feel the pain when you do something, which normally prevents you from doing things if you try to overexert yourself. When you're on these drugs, you don't feel that pain, so it appears that you have superhuman strength and you can do things that normal people couldn't do. The reason why you couldn't do it is because you would strain something, you would feel the pain.
That would normally otherwise kind of control somebody's behavior. So somebody experiencing this, they might have what we call superhuman strength. They might be able to lift things they wouldn't normally otherwise be able to lift. They might be breaking things where they then have blood like substances that you need to be cautious of.
Thank you. Now, in terms of, I'm going to just back up and talk.
I like this girl as a witness. She's not trying to push an agenda. She is trying to educate and give information. So I really like her as a witness.
A little bit more about the response to a medical emergency by EMS, again, based on your experience as a police officer and an EMT. You talked about how sometimes EMS will stage off site until a scene is clear and safe, correct?
Correct.
And have you heard the term load and go?
Yes.
Can you describe for the jury what that is?
Load and go, that would be, I think it's more like an informal term that's used with first responders. That essentially means that as soon as they're going to be arriving, it's a priority to get that person into the ambulance as soon as possible and get en route to the hospital as soon as possible.
Are there reasons why an EM...
Okay, the way she explained that is different than the way I had interpreted a load and go. I thought a load and go was a hostile situation and it's not a secure area and you move him, because that's what they did. When they said load and go, they moved George Floyd to another location that was safe and started to work on him. They did not load and go and haul ass to the hospital. They load and go and moved locations. So that is an absolute different definition than what she just gave. She said when you load and go, you bring him to the hospital. Hopefully the defense will be able to get that out and correct that.
EMT would, or a paramedic would choose to do that rather than administering first aid at the scene.
Yes.
What are those reasons?
By
Your Honor, this goes beyond the scope of the training.
If you know. If you don't know, just say so.
Well, he objected that she doesn't know, and he don't even know if she knows. So the judge goes, if you know, you can answer it. If you don't know, why would a judge, and I hear that a lot in court. If you know, you can answer. If you don't, you can say, I don't know. Well, of course I can say I don't know. What the hell do you think I'm doing up here? I took an oath and I'm just going to freaking make shit up that I didn't know? But I hear that a lot from judges saying, if you know, you can answer. If you don't, you can say you don't know. I'm like, really? I need your permission to say that?
I feel comfortable answering it. And by way of example, if maybe somebody had a knife in their chest, obviously, I mean, there's only so many things you can do for that person pre-hospital. Really, the only thing that's going to save that person is immediate surgery.
Sure. So
So again, she's focusing on load and go for medical only. He still hasn't got her to say sometimes the scene isn't dangerous. And if she doesn't say it, I would say, why do you think, from your experience, that the ambulance did a load and go and they didn't go to the hospital? They went 2 blocks away. And she may say, well, because his condition was so critical that if they drove and they didn't do any life-saving steps, he may die before they get to the hospital, and that's why they stopped. Which is okay an answer, but I'd like to know the answer.
there may be conditions of the individual that warrant that type of pick up and go.
Yeah.
And what about people in the area? Could that affect an
Unsafe
EMT's
environment would have been a
decision
better
to
wording.
load and go?
Yes.
How so?
If you had a very hostile or volatile crowd, I know it sounds unreasonable, but bystanders do occasionally attack EMS crews.
Oh, I really like her now because she's being straight up honest. And she's hurting the prosecution's case by being honest, and she doesn't seem like she cares. She's just being honest. Man, she made huge points on me right there because nobody wanted her to say that. Well, nobody on the prosecution team wanted her to say that.
So sometimes just getting out of the situation is kind of the best way to diffuse it.
Okay. And have you ever had to perform emergency services in not even a hostile crowd, just a loud, excited crowd?
Yes.
Is that, in your experience, more or less?
So he had to get confirmed because the defense is going to, or the prosecution's going to come out and go, what do you mean by a hostile crowd? And then she would have to say throwing things. And then he would say, well, if people are filming, does that make them hostile? And she would say no. So now he's trying to get her to say just a loud crowd so the prosecution can't come back and negate what she just gave him as a great statement.
Difficult.
It's incredibly difficult.
Why?
Because if you're trying to be heads down on a patient that you need to render aid to, it's very difficult to focus on that patient while there's other things around you. If you don't feel safe around you, if you don't have enough resources.
Man, she's a good witness. You go, girl. I like her. Not because of her hair, not because of her makeup, but because she's being honest and a fair witness with no bias. From what I'm seeing in her testify, I didn't see when the prosecution questioned her. But from what I'm thinking, I think she was pretty fair with him too.
It's very difficult to focus on the one thing in front of you.
It can be distracting.
Absolutely.
And so does it make it more difficult to assess a patient?
It does.
Does it make it more likely that you may miss signs that a patient is experiencing something?
Yes.
See, I would go, does it make it more difficult to give the patient 100% of your attention because you're distracted and looking at threats and possible fearing for your safety? So therefore, it's much easier to misdiagnose a patient or miss signs of a patient.
And so the distraction can actually harm the potential care of the patient.
Yes.
Good question.
I have no further questions.
Oh, man, she was a good witness for him. Great cross. Man, a cross made huge points on the use of force and this witness. Let's see how the prosecution comes in and tries to clean up this muddy water.
Our officers.
No change in her behavior, her stance. You notice in the other witnesses, I was saying their demeanor changed. They automatically got defensive, crossed their arms, did things for the defense that they didn't do for the prosecution. Because all the witnesses we've seen are prosecution witnesses. They're helping his case. He's calling them. They're his witnesses. And she doesn't change. It is what it is. She's just telling the truth.
Trained that sometimes they have to provide emergency medical services in less than ideal conditions.
Yes.
Oh, isn't it true that sometimes, you may have to in a crisis or in a hurricane to where there's chaos, but that's different in a natural disaster than it is with an angry mob crowd where there's been riots in the past months and there's been burning and looting and there's been attacking and officers are getting urine and water thrown at them and are getting shot in the streets and there's all kind of violence from a particular crowd, we'll say. Burn, loot, murder. Burn, loot, murder.
the rendering of emergency aid in practice does not happen in a classroom setting, does it?
Correct.
Right, and so you're in the environment as you find it. Is that right?
Yes.
And in terms of a crowd and a crowd being hostile, how would you define hostility?
He came up with exactly what I said. Damn it.
That would be a growing contingent of people around if they're
Loud, name-calling, failure to follow instructions of the officer, encroaching on the scene, not keeping their distance, yelling profanities, multiple people yelling profanities. That's what the cross should come back and ask if that's hostile.
yelling, being even verbally abusive to those that are trying to provide scene security.
Okay. What else?
If there's people trying to interfere with a crime scene or interfere with a patient, absolutely.
Perhaps use a weapon.
Yep.
Throw rocks or bottles.
Yeah.
See, he wants hostile for the jury to see this angry mob, and then he wants to show the picture of them just with their cameras taking pictures, and they weren't violent.
Yes.
Something like
Lawyer
that
games.
could prevent someone from providing emergency aid. Is that right?
Absolutely.
Can the activities, though, of a crowd, the activities of a group of onlookers, excuse a police officer from the duty to render emergency medical aid to?
Okay, this is going to be an interesting answer, because she should say it may not excuse them, but it's reasonable if they can't do things, if the environment is not safe, or if they don't think they have numbers, a clearly defined crime scene to where they're protected and they're not worried about other threats, then they should. But all care is always told it's secondary to your safety, because if you don't take care of yourself, then you can't help anybody.
To a subject who needs it.
Only if they were physically getting themselves involved, I would say.
If they were physically prevented, if the officer was physically prevented from doing it.
Yes, if the officer is being physically assaulted.
I wanted to talk a little bit about some of the things you said were.
So he got her to admit and got a good statement that he's going to be able to repeat. You heard the expert say, the officer that trains, that unless they're being physically assaulted, they should not render aid. That's what that comment, that answer they got. That's why he moved on. He didn't want her to explain that or elaborate, because that's what he's going to use later when he repeats it in the closing.
Indicative of excited delirium. You said superhuman strength, is that right?
Yes.
And I think what you said was that it was because of the inability to feel pain. Is that right?
The inability to feel pain and to know your limitations. And the high excited heart rate. Your blood pressure goes up. Your heart rate goes up. Plus you get an adrenaline pump. So when you get an adrenaline, you can do things that you wouldn't normally be able to do. And that's what drugs does to the body. That should be your answer, but we'll see.
That's a part of it, yes.
And the inability to feel pain is something that you associate with, or you train officers to associate with excited delirium?
That it could be a case of excited delirium, yes.
And so if someone was actually manifesting a response to pain...
Can y'all tell that he's not happy with this witness? He does not have the same demeanor as he has when he's getting good answers and good questions. I mean, this guy's demeanor has totally changed. He's like, shit, this is my witness, and she did more for the defense than she did for me. I got to try and fix this.
Indicating that something was hurting them, then that would tend to indicate that they're not suffering from excited delirium. Isn't that right?
Rephrase.
What would
That's a
a
complex,
subject's response to pain stimulus suggest then, as it relates to excited delirium?
That was a compound question, too. He asked two questions. As it relates, why didn't you just ask the question? What is it?
Well, it may or may not be excited delirium. It's a little bit hard to predict, because no two people ever really present the exact same way.
Good answer.
So then how do you tell what it is?
Well, that's not up for us to diagnose. It's just a matter of taking in the information you have at that time to decide if this could potentially be a case of that.
Oh, great. So there's no absolutes. Man, the cross needs to come back. So what you said is you really can't tell. And if you can't tell, you're only teaching people to read the symptoms, so maybe they know. But there isn't really a black and white that every officer should or should not know. Oh man, I hope the cross comes back on this.
We just need to plan accordingly.
And you indicated that whatever excited delirium is, you look at it as a medical issue
Correct.
that needs treatment.
Yes.
You may look at it as a medical issue, but that doesn't negate that there's a previous criminal issue, or if somebody is fighting and actively resisting because of a criminal arrest, we don't ignore that fact. But we do need to realize that excited delirium is not a criminal act. That's the way that should have been explained for the jury. Again, their whole purpose of experts is to make sure the jury have all the facts so they can make a reasonable decision. It's not to sanitize the jury and you don't want to give them this part and you want to hold and you only want to know this, and if I'm not asked, I'm not going to volunteer. And that's not the purpose of somebody testifying as an expert trying to educate the jury so they can make a reasonable decision on their verdict.
And in terms of drug use as well, it's fair to say that if someone is showing indicia of drug intoxication, it can make them vulnerable,
Yes.
not just violent.
Correct.
Thank you. Nothing further.
Man, I hope he comes back. He's got a couple points that he could make.
Members of the jury, let's take 10 minutes. We have to deal with one issue. The witness will remain, however. So 10 minutes and we'll be back in touch.
So I don't know if he's got a question for her or not. Normally he dismisses the witness if he's going to take a break, or they will hold her. So it sounds like he might have some questions for her because he did not release the witness, which is good because she is a great freaking witness. And again, people are going to come back and say she's a great witness because she's helping Chauvin and I got my hat in the ring for Chauvin. That's not why she's a great witness. She's a great witness because she gives information fairly to both sides, no matter who it hurts or who it helps. It is what it is, and she answered the questions to the best of her knowledge. And that's what makes her a great witness, in my opinion. But I guess we're going to take 10 minutes. I don't know what the hell's going on here.
The hearing of the jury, but on the record. There was a sidebar at some point where these...
Oh, they must have kicked the jury out before they handled this issue. That's why he gave the jury a 10-minute break.
State objected to the excited delirium training material. And...
Why would the state object to the training that is given to the police officers? If I was on a jury, I'd be like, dude, this is your case. You're the prosecution. You're representing the government, and you don't want to admit the training that the government is giving their government employees? What kind of bullshit is that?
Essentially, I think, Mr. Slisher, I don't want to speak for you too much, that your preference would be that Mr. Nelson not be allowed to present it at this time, but only as part of his case in chief, which would require this witness to come back during his case in chief. Is that correct? It is. All right, and so that's the basic objection, is the timing as opposed.
Okay. So the prosecution says, this is my witness. I don't want you putting on your defense with my witness. You can call her back. And the judge may go for this, but he may ask the defense, if you've only got a couple questions for this witness and you're not going to call her back for other things, I think we can go ahead and get it done now. But if you have more questions or you plan on calling her, then hold this question till later. That's probably how this is going to be handled.
Opposed to the admissibility. Yes, sir. Okay, Mr. Nelson, what did you want to deal with?
If we could have a private conversation.
All right.
I wonder why you wanted to go private. Huh. Sometimes they want to go private because they don't want other people to know what they're whining about, or if they're trying to be sleazy, or they think it could make them look like, the jury's out of the room. So the only reason to go private now is he doesn't want the witness to hear what he's saying, or he doesn't want the TV to hear what he's saying. That's the only reason to go private now, since the jury's out of the room. So I'll pause it, and they're back.
I'm going to excuse you for the day. She can be excused at this point, is that correct?
Yes.
You can be excused for the day, but the defense would like to call you back during their case. And so Mr. Nelson will serve a subpoena on you at some point so that you've got it mostly for his contact information.
Why can't you serve her
Because
now
in the
and tell
interim,
her?
I'm going to order that your subpoena that you were previously served still is in force, and that you should, unless you hear otherwise, come next Tuesday at 9 a.m. But most likely, Mr. Nelson will be in contact to tell you when exactly, so you don't just waste your time coming down here.
Yes, sir.
Does that work?
Understood. Yep.
Okay. So, Mr. Nelson, how is that going to be served?
Department.
Normally, yes.
So I can just serve the police through the normal or through the Federation or something?
Yeah, absolutely.
All right. We'll make sure that gets done. But for today, you're excused. Thank you. All right. We'll be in recess until 2:35 at least, if not 22.
Okay, good witness. And he's going to call her back for his case, which is good. And you know what? He could be calling back some of these other people. All he's got to do is subpoena them. So we don't know. He doesn't have to tell the prosecution who's he's calling for defense. Not that I'm aware of. I don't know what the time frame is. I know for discovery, there's there's not like you can't discover something, 2 seconds before you're doing it. I discovered it. So anyway, I just read a comment, and I want to discuss that comment on one of my things. And someone said, I'm not sure what Rick is talking about regards to discovery. I could be wrong, and I think you are wrong. From what I found, unlike prosecutor defendants can't call on police agencies to help them investigate and respond to evidence they find. Actually, a defense attorney can call on law enforcement if he wants them to seize evidence. Thus, every jurisdiction, state and federal, has discovery rules requiring prosecutors to disclose evidence to defendants prior to trial. Okay. And what he's referring, you know what? I'm going to have to do a separate video on this because this is complex. All right, we'll end that there.